Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me every Sunday from 8 to 9 a.m. on this station where I bring you, the landowner, valuable information that you need regarding natural gas development here in Pennsylvania. If you are looking for high-quality landowner information, then this, my friends, is the show for you. At the Clark Law Firm, I focus on landowner and oil and gas right owner representation. I have not, will not, do not, never have, never will represent oil, gas, pipeline, or other energy companies. I represent the Pennsylvania landowner and only the Pennsylvania landowner. I am located at 1563 Main Street in Peckville, Pennsylvania, and I represent landowners, oil and gas right owners all across the state of Pennsylvania for such items as gas lease negotiations, gas lease amendment and modifications, those negotiations, gas lease reviews, consultations, and we're going to talk some gas lease stuff today. Again, the shows are all designed not to be limited. So you say, well, I already have a gas lease. No, we go much deeper than that. We look to develop a lot of information for you, and whether you're considering a gas lease, whether you're considering a pipeline agreement, whatever it is, I think you're going to find today's show to be informative. So I also represent landowners for pipeline right-of-way agreements. You've heard me say this. I say it to provide the base of knowledge that we're operating from here. I've done pipeline right-of-way agreements and negotiated contracts with over 50 separate companies for pipeline right-of-way agreements and related agreements across Pennsylvania. And my hope is that when I say that, you don't take it as, oh gosh, who does this guy think he is? But you take it as, wow, there's a lot of activity. There's been a lot of activity, and there's a lot of experience that we can learn from as we go forward. I have represented landowners for oil and gas pad agreements, damage release agreements, unitization, surface use agreements, meter sites, compressor stations, any agreement related about buying and selling oil and gas rights. Unbelievably important issue. If you're going to buy and sell your oil and gas rights and you don't have an attorney, you are making a serious mistake. Whether it's me or somebody else, you are making a serious mistake. So if you're considering selling oil and gas rights or buying oil and gas rights, get an attorney who knows what they're doing. You can always call us 570-307-0702. But if it's not me, it's got to be someone. So again, just circling around, I represent Pennsylvania landowners all across the state of Pennsylvania, the Commonwealth of Pennsylvania. So if you're looking for representation, again, you can always contact the office, 570-307-0702, 570-307-0702. And of course, go to pagasleaseattorney.com. Go to pipelineattorney.com. I've been doing All Things Marcellus, my weekly radio show, since 2010. So we have hours and hours and hours of radio shows available on pagasleaseattorney.com and pipelineattorney.com. We index the shows, so if you're interested in a pipeline show, a gas lease show, an amendment and modification show, they're up there. You can find them, listen at your leisure, and whether you're looking for representation or just good information, check out pagasleaseattorney.com. Check out pipelineattorney.com. Okay, getting a little lengthy in my intro, but before I go further, I do want to remind everybody, and look, this is a situation where, depending upon where you're located, this could be a pretty far trip for you, but anybody is certainly invited. But I want to announce again, I'm doing a free land owner only. Very important. It is a free but private seminar only for Pennsylvania landowners. You must pre-register, and we have to have your name, and we'll take certain information because, again, it's a private but free. No obligation, no private seminar, but it's only for landowners. And this one is going to be on June 15, which is a Wednesday, and it's going to be from 6 to 8 p.m. So we're talking Wednesday, June 15th, 2016, and it's at the Dean Center in Wellsboro, which is located in Tioga County, Pennsylvania, from 6 to 8 p.m. Very important also, you must pre-register. We announced the seminar last week, started to talk about it during the show. We are already at about 20% capacity. Do not think that you're going to be able to just walk in on the night of the seminar. I'm sorry, because we want to limit it to landowners, because we want to make sure we're hitting topics that the attendees are going to be interested in. You have to pre-register, or I apologize in advance, but you will not be able to attend. Also, if we meet our capacity, we're shutting down, and those are the only people that are going to attend. So I've done seminars in the past, and we found that people like to wait to the last day, last minute. Now, maybe it will be able to happen that way, but you have to pre-register. But we already, within 1 week, are about 20% capacity, and we really haven't done much promotion, for this seminar. So if you're listening and you're thinking, well, okay, I'll register the week of the seminar, the day of the seminar, I'm telling you now that that's probably not going to work. I don't know that we're going to get to capacity, but I know that in 1 week of talking about the seminar, we're already about 20% and maybe just a bit over. So how do you register? Call my office, 570-307-0702, 570-307-0702. You can go online. There's a place at the bottom. You can email us, and you got to enter in your information. We are not going to bother you. I'm not going to be bothering you, getting back or sending emails and our advertisements. That's not going to happen. But if you are not pre-registered and you are not a verified Pennsylvania landowner, you will not be able to attend. And once we hit our capacity, we are not accepting any more reservations. So again, pre-register. The seminar is going to be in Wellsboro, Tioga County, Wednesday, June 15th from 6 to 8 p.m. at the Dean Center. Register now. I sound like one of those TV commercials, but it's the reality of it. Once we're full, we're not going to take any more. We may have a waiting list, but get in if you're interested at all, and I think you should be if you're in the area and you think you might be. It's free. It's going to be great information. I'm going to take questions, and we're going to have people who are attending send me some questions. It will be extremely valuable. Can't wait to see the people. We've done another seminar there, great attendance, and we expect a lot more because last time we didn't even really advertise. So I can't wait to see everybody there. And again, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and we're going to get into it now. So, okay, into the show. Enough of the intro and into the show. So what I want to talk about today, and please stick with me because we cross many different subjects other than what I'm going to say right now. But what we're going to talk about today is some lease information, some basic lease talk, but much deeper than. So what am I talking about? Well, it is so important. Many people have a lease right now and do not fully understand, and this is most people, have a lease and do not fully understand what that lease means or what it says, especially relative to some critical issues. There are other people who are considering a lease now, or maybe you're going to consider a lease in the future. It is unbelievably critical, fundamental, that you must understand your lease and how it is going to impact you in the future. We have the basis of knowledge. We have seen people enter into very company-friendly leases, and we have seen how companies have developed and held on to this property to their benefit. Understandably, who wouldn't operate to their benefit? We've seen people who have entered into strong, friendly landowner leases, and we've seen how companies have developed under those leases have sought to extend or amend or modify the leases because they didn't like some of the terms, because they were more more landowner friendly than what the company wanted. So the landowner then has to be looking at, okay, well, what am I being asked to amend or modify, and what do I do? And there's other people right now sitting out there, and you have no lease offer, but you may have a lease offer in the future. And a lot of people probably will have a lease offer in the future. So what am I saying here? Well, as usual, something pretty profound. In this case, it is that you need to understand what is in your lease that you've signed, or what is in the lease or lease modification, amendment, or newly proposed lease that you are considering signing. Seems pretty darn basic. Well, that is, but I'll tell you, probably almost everybody doesn't fully understand your lease. Now, do you need to understand in extreme detail every single word? Well, probably not, but there are certain issues of your lease or areas in your lease that you better darn well understand, and still the vast majority of Pennsylvania landowners do not understand the critical provisions in their lease. And I see it all the time. I mean, I've never spoken to a client. I've never spoken to a landowner who has understood every single aspect of their lease. But if nothing else, we need to make sure that you understand the critical aspects of your lease and how they're going to impact you in the future. Now, what am I saying? Well, it's critical. And now, look, we want to understand a lot more of your lease than just this, but a couple things to point out. It's certainly critical that you understand your existing lease when you're looking at, number one, an extension or a modification or amendment of your lease. I've talked a lot all this year about lease amendments and modifications and extensions because companies have quit drilling, so they're coming out to landowners and asking to extend and modify or amend your existing lease. And in many cases, in my opinion, not specific advice for everybody here or anybody, but in many cases, you're going to say, heck no, I don't want to extend this lease. And there's very good reasons why. In some cases, you may want to extend or modify the lease, but in order to make that decision, you better darn well know what is in your existing lease. Or how can you decide if it's in your best interest to extend it, to modify it, or change it and go into the future with those changes? So you better sure as heck understand what in the world is in your lease, and especially in your critical sections of your lease. So that's just one example, and that's something that people are dealing with every day in today's market. Another area, we need to know if what's in your existing lease, because if you have an existing lease and you have, say, a 5-year lease and we've come up to 5 years, or maybe you have extensions in your lease, whatever that case may be, we need to know, is all of your property held under this existing lease? Or maybe, which is something very common today, because of the lack of drilling and development, that you may have acreage that is eligible to be we'll say released or surrendered or given up by the company in return to you. You may have acreage that's eligible to be returned to you that you could release in the future, enter into a new lease, or not, but it would be returned to you. So we got to know what's in your lease. We got to know about your Pew clause. We got to know, hey, my lease has expired relative to some acreage, maybe not all of it, but a portion of your acreage. So we have to understand that. I've done shows recently on this, and because of the lack of drilling, we're seeing many leases that have acreage eligible for release. And finally, for today's purposes only, you also have to understand what is in your existing lease relative to future surface activity on your property. What do I mean there? Well, companies are coming up to landowners and saying, hey, we want to install a pipeline, a roadway, maybe a well pad. And you need to know immediately, don't sign anything pull out your lease and get some assistance, because you need to know what rights the company does have or doesn't have under the terms of your current lease. And believe me, guys, believe me, there is a lot of confusion out there. You need, if you're having a request for a pipeline right-of-way agreement, if you have a request for a roadway agreement, a meter site, any future activity on your property, well pad, you need, your first call should be to an attorney who knows what they're doing to identify your lease rights, so you know, can you say no to this pipeline, roadway, surface site activity, well pad? Can you negotiate it? What is your leverage? Because those are enormous points. And as always, you cannot rely on the company landsman to educate you. They do not represent you. They represent their employer, the company. They represent the company. You need a representative of your own. And again, whether it's me or somebody else, you need your representative. Somebody who's working for you, has the experience and knowledge to assist you, the landowner. Okay, we're up against the first break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me every Sunday from 8 to 9 a.m. on this station, and I'm going to be right back after this extremely important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me every Sunday right here on this station from 8 to 9 a.m. for the valuable information that you need as a Pennsylvania landowner. So, okay, I'm going to jump back into this, and we're going to really start diving into a lot of content here. So, okay, what am I talking about? I'm talking about how landowners, as a general rule, and it's understandable. I mean, look, the first contract I looked at, I didn't know what the heck it meant, but we got to understand our existing oil and gas lease, or, of course, any lease offer that is presented to you, the landowner. Why? Well, if you have an oil and gas lease extension or a modification or amendment of your oil and gas lease, you sure as heck better know what's in that gas lease and what is asked, what the company is asking to extend or what they're asking to modify or amend. I've done a lot of shows on that subject this year because of the lack of drilling. Companies are having leases or facing leases that are expiring. Sometimes they're expiring in total or in whole, meaning the entire lease is going to expire. They come to you and request an extension of an existing lease, or they ask you to modify or extend that existing lease. Please stop signing these documents without getting assistance from a knowledgeable oil and gas attorney who can help you. Whether it's me or somebody else, please stop signing these documents, because most people, well, everybody I've ever talked to has not fully understood every aspect of their lease. So there are so many hidden things in your lease, very important, that you probably don't understand, that you need to understand. So you hear me say, I'll just leave it. You can do a review and consultation anywhere across Pennsylvania, where we can do it by telephone. We can do it in office. I do most by telephone. But you just got to stop signing these documents, because in most cases you realize, boy, I don't want to sign it, or in many cases you don't want to sign it, or you can do better than what's being offered to you. So please stop signing everything and get good information. Another important issue that I'm not going to go too deep into today, but I've been talking about in the last few weeks as well, is you have to know your lease, and you have to know whether you may have acreage. You may have what's called a pew clause, and whether your lease, maybe it's not up for being, maybe it's not going to terminate for the whole lease, the entire lease, but maybe part of the lease is going to terminate or is already terminated. You need to understand, hey, if I had a 5-year lease and we're in year 5 or 6, or if I had a 5-year lease with a 5-year extension and we're in year 10, or if I had a 5-year lease with a 3-year extension and we're in year 8, you need to understand what that means. Are you held by your lease? And maybe you are, but is but is all of your property held? And what we're seeing in a lot of areas is that many people have leases that haven't expired in whole, but they actually have expired in part. Meaning that if you had 100 acres, maybe 90 are still under lease, but 10 really have expired. And you have to write a letter to the company and say, hey, my lease expired relative to these 10 acres, and it could be 20, 30, 40, or 95 acres, whatever that number is, but you need to write to company and said, hey, give me a release. One step further. This is the thing that gets confusing. It gets complicated. And gosh only knows how many people out there are in this situation. But there are many leases that were signed, and even in 2006 and 2007 that I see, where they have what is called a depth severance provision, or an aspect of a depth severance. So when you're looking at your lease and you say, hey, the company has only drilled to the Marcellus shale formation, well, you may have language in your lease that says that that's all the further they're allowed to drill under the terms of this lease, meaning that the company cannot drill to the Utica or other deeper formations under the terms of your lease. So you can write a letter to the company, your lawyer can write a letter to the company and say, hey, you're only down to the Marcellus. I have this certain language in my lease that means you can't go any deeper. So I would like you to release or give up your drilling rights to the deeper formations. That can be very, very beneficial, because then you can enter into a new lease in the future, if you want, for those deeper formations like the Utica Shale Formation. So it's something that we see a lot of today. Northeastern Pennsylvania, you don't see Utica wells. You don't see very many. North Central, you see some, but you see a lot of Marcellus wells, and deeper formations are eligible for release, but nobody knows this. We also see in southwestern Pennsylvania the same type of thing. Most of the early drilling was this horizontal drilling was for Marcellus formation. So if you have language and you need to look at your lease and you need to understand this, that makes the deeper formations, or has the deeper formations are eligible to be released or returned back to you, you need to start writing the company or having your attorney write the company and get these releases. They then have to be filed at the courthouse and recorded. So there's some work there. Some landowners can do it on their own. Some need assistance, but you need to know, does this apply to you? And what can happen too, company can come out and offer you an extension, a modification, whatever that may be to your lease, an amendment, and you don't quite understand it. And it very well may be that they want to extend your lease because they want to buy more time or get more time so they can drill deeper and hold the Utica formation, which they now have no rights to because of the language in your existing lease. So many people are signing extensions and have no idea the true motivation by the company to request the extension. And I'll tell you, you can't fall for this line. Well, yeah, your current lease only allows us to go to Marcellus Shale Formation. We've drilled these great Utica Shale Formation wells, and we want to drill them for you. We want to drill them for you too. So if you sign this document, it will give us the right to go deeper into the Utica Shale, and we're going to go down there, drill these great wells, and it's going to be very profitable to you. On the flip side, it's also going to be, if that all happens, it's going to be very beneficial to the company. So think of it this way. If you have the language that says at the end of my primary term or initial term of my lease, you company are stuck, you can't go deeper than how deep you've drilled as of that time. So if my lease terminated in 2016 and you've gone down to the Marcellus, well, yeah, maybe you hold the Marcellus formation, but everything below that, you need to return to me. So essentially, guys, it's a new lease for the deeper formation. So you don't want to just simply say, okay, where do I sign? You never want to listen, here's specific advice for everybody. Don't simply just sign. That's one of the few times where I'm going to say this is advice for everybody. Do not simply sign agreements. Get assistance. And I do these reviews and consultations, and I'm sorry to go commercial on this, but I'm telling you, it takes about an hour or two, and you're going to understand your rights. You're going to understand, hey, do I think you're going to have the tools to decide? Do I think this is a good decision? Do I want to move forward? Do I want to hold off? How do I want to handle this? We're talking about, and this isn't out of desperation. This isn't out, I need business. This is to explain to you what this process is. And this process is literally an hour or two of time typically, in 90% of the cases. And you have an understanding, okay, here's my situation. How do I want to handle it? Then it's a small investment for a very important topic. And please understand, again, I'm not saying this because I'm saying, hey, I need a business. I'm saying this because I do not want to have landowners to be intimidated or afraid of legal fees and not seek advice. Again, go to pagasleaseattorney.com. Go to pipelineattorney.com. Read the testimonials. Read the information there. Again, this isn't just a thing to beg for business. I want you to be comfortable, but I want to make sure that you understand that there's somebody out there that for 2 hours, maybe an hour, depending on how complicated, but usually between 1 to 2 hours, who can give you the tools that you need to decide, hey, how do I want to handle this? Then if you need additional assistance, we're here. If you don't need additional assistance, we're here if you ever do in the future. But that's the way we do things. And when I say, look at the testimonials, it's only to say, look, I know I say this sometimes. My parents, I grew up in Armstrong County, which is in western Pennsylvania. My dad was a steel worker, worked in a mill. My grandfather's steel worker, worked at Allegheny Ludlam. They both did. Had a small farm. My father still farms in that farm today. And I know that when I grew up, there was no one in my family had gone to college before me. And when I grew up, I never heard of a lawyer. My parents, never had a lawyer. They might have had one for a will. I think they maybe did, but never even heard of a lawyer. So didn't know any lawyers. And the thought of my father contacting a lawyer or my grandfather for something in the farm, if there was oil and gas, which they entered into an oil and gas lease years ago, was just something that was never even thought of. But times have changed. These type of agreements are much more complicated. They're actually developing substantial amounts of gas, enormous amounts of gas under these agreements. These agreements went from $1 to $5 an acre to $5,000 to $6,000 an acre. They went from 12.5% with no deductions to as high as 21%, or 12.5% with deductions, to as high as 21% without deductions. We need to turn this. We need to change that mentality. Not just so lawyers can get business. No, so you can get a fair deal for you. This is your asset. This is one of the number ones. And my family, and to this day, the farm is the largest asset. That property is the largest asset. It's too important. And there's too much money involved not to handle this properly. And so that's why I say we can do these evaluations typically in 2 hours or less to give you the tools you need, and it's going to be money well spent. You will have such a much better understanding, of your options, why this is occurring, and what are your alternatives, and how maybe you want to handle this going forward. My job is to give you the tools so you can make the right decision for you and your circumstance. My job isn't to tell you what to do. It's to educate and assist you and guide you, maybe make recommendations, suggestions, but that's the way we look at it. So I want to make sure that people aren't intimidated or afraid. Give us a call. Sorry about commercial here, but give us a call, 570-307-0702. Learn what we do. Learn if this may be something that would be helpful to you. And I'm going to tell you, in almost every case, I'm pretty confident that it will be. All right, we're up against it here again. But before I go to break, I want to remind everybody again, I've been representing clients across Pennsylvania, and it's certainly in the northeastern part of the state, on the Atlantic Sunrise, the Transco, and other FERC, FERC, which stands for Federal Energy Regulatory Commission pipeline projects, and of course, other projects as well, all pipeline projects. But I just, things are starting to step up some. And if you haven't consulted with an attorney, I would highly recommend that you do. I know I'm a broken record if it's me or somebody else, but you need to. We're having, I've had several clients who have reached agreements, and I think that there may be certain opportunities out there today that you need to be looking at and possibly taking advantage of, because we don't know, there's uncertainty in the future. So, it's never too late to get information. So if you're out there considering this type of an agreement, and any pipeline agreement, but a FERC pipeline agreement, because we are a sensitive time in some of these, I just highly recommend call someone. You can call us 570-307-0702, 570-307-0702. One thing that's a shame, people are signing pipeline agreements without representation and thinking that, okay, well, I understand everything. I'm doing the best I can. I'm going to do the best that can be done. I can read these documents. I understand them. But there's so much more behind the scenes. Leverage assessment, terms, additional addendums, and protections that you have to understand that you may not know about. So please, we're losing opportunities. We're not taking advantage of them, and we got to stop that. So you can always contact me for any representation at 570-307-0702. Go learn more. If not even for representation, go to pagasleaseattorney.com, go to pipelineattorney.com, but get information. Okay, we're up against it. I'm over my time. I'll be right back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I'm with you every Sunday from 8 to 9 a.m. on this station. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right into it because we're going to get to some more content here. Okay, so talking about your leases, why you need to understand your lease rights, why you need to understand your lease. And first, I'm just going to summarize. We say if you're going to be looking at a lease extension or modification or amendment, if a landman comes to you, company comes to you, we want to amend, modify, or extend your existing lease, you sure as heck better know what's in that existing lease. And specific, breaking my rules, in this case, specific advice for everybody: stop signing, put the pen down, get some assistance, because you gotta understand your existing lease, and this may be a tremendous opportunity for you to do better, to improve on the lease that you signed in the past. We do not want to miss opportunities. We want to maximize them. We want to slam them out of the park. We do not want to miss opportunities. We want to take advantage of them. Another example is you may have the opportunity, another opportunity, because of the down market, because of the lack of drilling. That presents opportunities in many cases for landowners. You may have acreage that right now is eligible to be released or returned to you, so it's no longer under lease with the company. You need to understand that, and that can get very complicated. So we need to make sure that people aren't missing opportunities, that you may have a pew clause, you may have a clause that says that your lease only goes to a certain depth, maybe the Marcellus Shale Formation. You may have a pew clause within your lease that allows you to have those deeper formations released or returned to you, and that can be a tremendous opportunity. So again, it falls into, you need to know your lease, you need to review your lease, but also if you're asked to sign anything, you need to talk to somebody who knows what they're doing to make sure that you really understand why you're being asked to sign this document, and what are you giving up by signing it, and can you do better? Do you even want to sign it? Do you want to negotiate it to do better? And I've seen over the last many years, but certainly over the last weeks and months, people doing much better. Again, opportunities. As a general rule, if you're just signing, you're not making wise decisions. It's just, that's the reality. And I'll say it again, I mean it with all my heart. Whether you call me or call someone else, call someone. I don't want to see anyone taken advantage of. Anyone. And I don't want to see, let's dial it back and say not just taken advantage of. I don't want to see anyone not take advantage of an opportunity. So maybe you're okay with what you signed, but here's the thing. Maybe you could have did a lot better. Maybe you could have increased your royalty percent by 1, 2, 2.5, maybe even 3 or 4%. Maybe. You got to find out, because you can't, literally thousands of landowners have left money on the table, combined tens of millions and probably easily into the hundreds of millions of dollars if you're looking at royalties, future royalties, the lifetime of these leases. I'll say it again. I say it often. Stop signing agreements. It's never too late to start making better decisions and taking advantage of future opportunities. So stop signing, get information, whether it's me or somebody else, stop signing. Don't just simply rely on the landman or company representative who doesn't work for you. You're not paying them. The company is. The company's paying them. So make sense. Get somebody who can assist you. And again, I'm saying, just to tie in, usually those initial consultations are an hour or two, and it's so hard to try to run this balance or walk this tightrope. As for a listener, I want you to understand, I'm saying this because I want you to understand what's involved from our end here. Not, oh gosh, I need this business, what am I going to do? It's about giving you this picture of what it takes to get the information that I'm talking about. So if you want to call me, you can call me. I'd love to help you. That's what we do. But if you don't call me, please stop signing and call somebody. Call somebody. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always reach out, 570-307-0702, 570-307-0702. Represent landowners and only landowners all across Pennsylvania. You want to learn more? Give us a call. Go to pagasleaseattorney.com. Go to pipelineattorney.com. All right. The third point, and this is such an important point, as virtually all of these are, but this is another extremely important point. Well, again, they're all extremely important points. But here's another way in which it's very important, a lot of that, that you understand your lease language. And it comes back around to any time that you're asked to sign a document, usually it in some way has an interaction and is related to your oil and gas lease. What do I mean by that? Well, you sign an oil and gas lease. You have an existing lease. Every existing lease addresses future development rights on your property. Some leases say that the gas company cannot operate on the surface of your property, that they are precluded from installing pipelines, roadways, well pads, meter sites, valves, all kinds of surface activity. Some leases completely and totally preclude surface operations on your property. That's an outstanding lease. I call them no surface leases, meaning no surface operations under the terms of the lease. I love those leases. Love them, love them, love them. And I could argue, hey, they're not necessarily good for a lawyer, because then you don't need a lawyer for a pipeline right of way or other future agreements. Hey, that's fine. What do we want to do in every case? Get you the best agreement, and the best agreement for you to address your considerations. But most of the time, you're not going to be able to get a no-surface lease, a complete no-surface lease that says, hey, you can't touch my property. Usually, you don't get that. Most leases do allow for future surface activity. So then the question becomes, so if most leases allow for pipelines, roadways, well sites, those type of future surface development, you need to understand, well, are there restrictions? What exactly does my lease allow for? And I'm going to tell you guys, that most leases have restrictions on what type of surface activity can occur. And how do you know that? This is elementary. How do you know that? Well, when a company comes out to you and says, hey, we want to do a pipeline right of way. We want to put a roadway in here. We want to put a well pad on your property. Here, we want you to sign this document. Well, the reason why they want you to sign a document in many cases is that they don't have the right to do what they are requesting to do under your oil and gas lease. Or you may have certain rights under your oil and gas lease that by signing the document that they are requesting you to sign, that you are waiving or giving up those rights. This is an area where I'm not being specific for any individual, that I'm talking about general advice. So there are cases where sometimes, yes, this pad or well pad is going to clearly be allowed on the property, but there are many other cases where you have input. You have the ability to object, to negotiate. There are different things that you can do. Pipelines are the premier example, that if you're asked to sign a pipeline right-of-way agreement, if you are not consulting with an attorney, you are making a tremendous mistake. And in my opinion, if you are, so let me just step back here. If you are relying on the gas or pipeline company landman to advise you of your lease rights, you're making an enormous mistake. Enormous mistake. You need to understand, do you have the ability to say no to the pipeline, roadway, or well pad? Do you have the ability to negotiate it? What rights do you have? I've done many shows in this. I'm not going into those details now, but I can assure you it gets very complicated in many cases. And if I wanted to present it a certain way, I could make a landowner feel that, hey, well, might as well sign. Or if I want to present it in the way that I'm going to present it to my client, I'm going to explain exactly what rights they have, exactly what leverage they have, what we have seen in their area, what we have seen this company do, and we're going to make sure that you know where you stand and how you want to handle it. And I have seen, I'm going to easily say, and look, this is just as an example, that pipeline right-of-way agreements, I've done hundreds upon hundreds, and there is no doubt that I have seen my clients easily get combined well into the tens of millions of more dollars above the initial offer that the company made. So if the landowner just simply signed that initial offer, they would have missed out on substantial additional compensation, as well as substantial additional property protection terms. But we have to look at this as an individual basis, because everybody's lease is different and everyone's property is different, where the development is being located, what type of gas, whose gas is going to be ran through any pipelines, where the well is going to be drilled into from the well pad. We need to really dive into all of these issues. And you need that, guys, from the landowner perspective, not from the company perspective. I'm up against my third break, but we have one more important segment to come. Remember, I'm here with you every Sunday from 8 to 9 a.m. on this station, and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I want to remind you again, I'm here with you every Sunday from 8 to 9 a.m. Okay, I want to jump right back into it here. We're talking about understanding your lease language, which also would lead to, if you're being offered a lease, you need to understand your lease language. Why that can be important in so many future activities or future agreements or further surface development. We touched on earlier in the show that if you're asked to sign a lease modification, extension, or amendment, it's critical to know what's in your existing lease. Another fairly common scenario today is that landowners have acreage that is eligible to be released or returned to them due to language that is in your existing lease, under what's typically called a PEW clause or a depth severance clause or a combination of the two. So you need to understand, do I have any acreage that's eligible to be removed from this lease? And what do I have to do in order to have it removed? Which is typically to write the company, to get this release document, and then to record it at the courthouse. Something that landowners are not taking advantage of and need to take advantage of. Typical example, we need to release the Utica Formation, especially in north central and southwestern Pennsylvania, but also northeastern Pennsylvania. We need to release the Utica Formation because you can enter into a separate lease for the Utica Formation, which may be better than, in a lot of cases, it will be better than the existing lease terms that apply now. And we need to make sure that you're not extending or modifying or amending your lease to allow the company to access Utica or deeper formations when, if you did not sign the document, they would not be able to access that formation. But here's the thing, guys. They want to. So you can have another leasing opportunity. So we want to make sure that we're taking advantage of opportunities. We can't let opportunities pass. Too many people have let opportunities go by them in the past. We need to stop that. We need to seize opportunities, not wave as they go by, and we can control that. And then the final point, just for today's purposes, is if you're asked to sign any future agreement, you need to understand, what does my gas lease say? Why am I asked to sign this future agreement? Can I say no? Do I have to sign this future agreement? And virtually, in 99 out of 100 cases, you don't need to sign anything. And so a company landman or company representatives may say, well, landowner, we can do this under the lease, so here, sign. Well, if they can do it under the lease, why do you need to sign? Well, they can turn around and say, well, we're going to give you this money if we do it by this separate agreement, but if we do it under the lease, you're not going to get this much money. Well, in some cases that may be true, but in virtually every case that I have ever seen, and I have seen hundreds upon hundreds upon hundreds, when you sign a new agreement after your existing gas lease, you are giving the company more rights than they had under your gas lease. You are giving them additional rights. Pipeline agreements are the best and clearest example. You are giving them additional rights. Most cases, once your lease terminates, the company cannot have pipelines on your property. But if you sign a pipeline right-of-way agreement, in most cases, those pipelines can be on your property until the end of the earth. The gas lease is going to terminate before the end of the earth. Your pipeline agreement may never terminate. In most cases, won't terminate. So you're at bare minimum, and I cannot stress enough how I mean bare minimum, giving the pipeline or gas company additional pipeline rights to have those lines in as long as they want. But it gets much more important than that. In the vast majority of leases that I see, the vast majority, and if you get one thing from today's show, please get this. The vast majority of leases do not allow pipeline or gas companies to run gas from all across the region across your property. Most don't allow it. Or if they do possibly allow it, once your gas lease terminates, the right to have those pipelines there running this gas also terminates. The gas and pipeline companies do not want to be installing pipelines on a property when those rights to have those lines there terminate when the gas lease terminates. Maybe 50 years, maybe 80 years, maybe 30 years, maybe 100. But there's a termination time frame. So a company can say, well, yeah, we have the right to run these pipelines across your property. Here, sign here, and we're going to give you this money. Maybe you don't want the pipeline. They say, hey, sign here, give this money. If you don't, we're just going to install under the terms of the gas lease. Well, I've seen that in many cases, that bluff been stated over and over again, and it just doesn't happen that way. So again, I can't stress enough, this isn't individual advice, but this is giving you and hopefully tuning you into the fact that the company may not just be trying to give you free money. Think about when they leased you. Think about when they took deductions or they take deductions. Are they trying to give you free money then? When does the company give you free money? Very, very rarely. Go check out their stock reports. Go see if they say, well, we gave away a few million in free money, or 10 million, 20 million, 100 million in free money to Pennsylvania landowners. You're not going to see that. They're not in the business of giving you free money. So why are you being offered this agreement? Why are you being offered additional money? Is it because the company wants to be a good neighbor? Is it because they just want to be nice to you? Is it because you're a really nice guy, you're a really nice lady? Or is it because they're getting something in return? What do you think? Why are they offering you free money, in their words? Well, I don't know. You're not catching that very often. The only people I see getting free money are my children. So we have to identify. Why are you being asked to sign this agreement, which may be very simple: pipeline, roadway. Why? We want to put a pipeline in. But why this agreement? Why not go under the gas lease? We need to understand exactly what are your rights under your oil and gas lease. I've talked about this before. Believe me, it gets extremely complicated to understand through the development process why a company may have rights to do something today, but those rights are limited. So a company landman can say to you, well, we have the right to install this line or this roadway under this gas lease. Well, in some cases, that may or may not be true. But in other cases, it may be true, but only to perform limited activity. And by agreeing to this agreement, you're going to allow a much more additional activity that they don't have the right to do. Or it may be that those rights and what the company wants to do terminates when your lease terminates, and they want to have those rights for hundreds and hundreds of years. So we have to identify this, and this can lead to not having a pipeline agreement that you don't want, or it can lead to substantially more money and substantially more property protections. And I'm sorry to go commercial, but if you're asked to sign these, I don't care where you are in Pennsylvania, give us a call, do a review and consult, usually 2 hours or less, 570-307-0702. We got to stop the signing. We have to seize opportunities. We do not want to lose or miss out on substantial additional compensation or substantial additional terms that are going to protect your property. We can't miss out on these. And hundreds upon hundreds of landowners already have. We need to stop that. We need to take advantage of every opportunity. Okay, before I wrap up, I just want to remind everybody again about the seminar that we're doing in Tioga County. It's Wellsboro. It's going to be at the Dean Center. It's from 6 to 8 p.m. on Wednesday, June 15, 2016. You must be a landowner to attend. You must pre-register to attend. Must. We are only going to let in pre-registered landowners, and if you don't pre-register, you're not going to be able to get in. Spaces are truly, you hear this all the time. We've been advertising for less than about a week, and we have already over 20% capacity filled. So please make sure that you're getting involved and you're pre-registering as soon as possible. All right, I'm up against it. You have been listening to All Things Marcellus with me, Attorney Doug Clark. I'm here with you every Sunday from 8 to 9 a.m. Have a great week, everyone.